Hello, folks. Dustin Zarni here, Democratic Elections Commissioner for Onondaga County. Welcome to Commissioner in a Car. Today is Sunday. It is August 16th. And today's Commissioner in a Car is one court case down, one more to go. And that is referring to the two court cases that the Onondaga County Board of Elections is involved in. One from the primary with the County Leg 16th race, which wrapped up this last Friday. And then, of course, I'll touch on the ongoing court case with the veto, no veto thing in the term limit. So, sorry, I've been a little bit about a month off of these commissioner in cars because, well, it's been busy down at the board. And it started on July 5th when we were put into an injunction with the County Leg 16th case, and then July 17th when the veto, no veto thing broke. And because of all of that, I've been on TV, in the paper, all over the place on all of this stuff. And I felt like that was enough news coverage. I was sharing those. You didn't have to hear from me on my podcast. I wanted to take a couple weeks off anyways, just to reset. That did not happen. I've been very busy for this last month because we haven't been able to finish counting the primary. But finally on Friday, we got a dismissal of the case in County Leg 16. And because that's finished, I'm going to talk all about the history of that, just to get you up to speed. There was a paper article about it, but I'm going to go from the beginning, and then on the veto no veto case, the YETO, as I call it, that is ongoing litigation, and I tend not to comment on ongoing litigation. I released a statement about why I started that litigation, but I'll touch on it briefly at the end of this podcast. So let's go back to the County Leg 16th race and what happened in court, why it took so long. And I just want to go through it because I think a lot of people are wondering why we haven't certified the primary yet in full. And that's because of this last case. So we ended election night with Charlene Tarver and Niatwa Bullock were in a Democratic primary for County Leg 16. This is very important because there is no Republican candidate in that field, although Charlene Tarver is also on the Working Families line. Charlene Tarver happened to be the Democratic nominee, which means that OCDC nominated her, but Niatwa Bullock mounted a primary challenge. And on election night, at the end of the unofficial totals, Charlene Tarver was up by about 10 percentage points, represented about 78 votes or so. And what happened was, Niatwa Bullock's team had a unique GOTV operation. They decided to go out and have agents of her team, mostly her family members, go to other family members, people they know in the community, and other voters that wanted to vote and have them fill out early vote by mail applications. And instead of having us mail the ballots to the people, they were picked up by agents. They're called agents in election law that can pick up the ballots for you and then give them to you, and then you vote on them and they come back. Now, this is normally not done. That doesn't mean it's illegal. We have early vote by mail applications now, or early vote by mail ballots, which are extensively a little bit like absentee ballots, which means they can be voted by mail, but you don't need an excuse. And according to Niatwa Bullock's campaign, they decided to use this to get people to hand deliver ballots to the citizens, let them vote, and then return them. So, as you know, on election night, we try to get as many mail ballots into the unofficial totals as possible. Any mail ballots received in our office by the Sunday before the election are canvassed and part of the election night totals. The Bullock team had about 100 or so mail ballots that they had picked up, 150, I believe, that they had picked up through this operation, but about another, 80, 85 or so ballots that were returned to us on election day. Not all of them by the Bullock campaign, but a lot of them by the Bullock campaign. Now, all of these ballots were signed by the voters, and presumably voted by the voters. And what happened then was on June 23rd, the Tarver campaign was up by quite a bit. But then on June 30th, when we did our scan of all the ballots that came in on post-election day and on election day, the Bullock campaign had closed that gap, and it got down to 5 votes. Now, 5 votes is actually, although that would be within the hand count margin, is actually kind of hard to overcome. But in addition, because of our canvassing, there were additionally 22 ballots that on June 30th had not yet been counted and could not be counted because our bipartisan team had determined that the signatures were off. Now, it's different in every case. Every ballot is individually reviewed by a bipartisan team and then a set of managers as well. And these 22 ballots, sometimes they had people who just put their initials. Sometimes a husband signed for a wife or a wife signed for a husband. That happens from time to time. And that's why we have what's called a cure process, which means that we send out notices to the voters, and the voters then decide to cure their ballot to have their ballot count. Now, they can't submit a new ballot, but they can submit this cure affidavit, which will cure their signature, which means it'll make the ballot good to count. Well, those cures had a due date of July 6th or July 7th. And as of June 30th, when we found out that it was actually only a 5-vote total because of all the late arriving mail ballots, the Tarver and Bullock campaign found out that these cures were probably going to flip the election or have a chance to flip the election. And a lot of these cures were people that were identified by the Bullock campaign and in part of that vote by mail operation that they had. And so the Bullock campaign started going out, talking to the voters, seeing if they got the cure notice, and having them return the cures. The dates to canvass the cure was July 7th. We were going to canvass all cures on July 7th that were received. And unfortunately, on July 5th, we were served by the Tarver campaign an injunction signed by Judge Neary of Onondaga County Supreme Court, preventing us from counting any more ballots. And at that point, by July 7th, 14 cures had come back from these 22 ballots saying, we want to cure our notices and thus allow these ballots to count. But because of this injunction, we were not allowed to count these ballots. Now, the Board of Elections, this is a case where we agreed, both Commissioner Ryan and I, that we wanted to count whatever cures came in that were deemed proper. Now, we hadn't even ruled on the cures at the time of the injunction, so that still has not been done. And we submitted paperwork to do that. Unfortunately, there were a couple of delays. Usually election law cases go really quick, within a couple weeks. But first, the Tarver campaign requested a delay of the hearing because they wanted a a response of a FOIL that they did with the county law department on voter signatures and all of that. That took about 30 days to prepare. We had a court date set for August 3rd, but then on August 3rd, just before August 3rd, the Tarver campaign then hired a lawyer, finally, because Charlene was doing this all herself, what's called pro se, representing yourself. Ms. Tarver was a former lawyer. She's not licensed in New York, but she was representing herself. That's not something I ever recommend. The Board of Elections was represented by outside counsel Ed Carney, former Supreme Court Justice, and Dan Berman handle our case because both Kevin and I agreed that we were a ministerial agency in this case and we just wanted to count the ballots, and that the claims of fraud that Ms. Tarver was making in her papers were not just unsubstantiated, but even if they were to be substantiated, these were on ballots that we've already counted, and there were no fraud claims on the 14 ballots that were out there that we wanted to count, or at least canvass. Remember, canvassing is different than counting. Canvass means we're ruling on it, and then we count. But Ms. Tarver, who was acting pro se before, hired a lawyer, some guy, Mr. Glickman out of Brooklyn, and then the lawyer asked for time to get up to speed on the case. And I was very frustrated, but the Judge Neary gave him till August 14th. So now, Election Day was June 23rd, and we were going all the way to August 14th and not being able to, I had a little glitch, not being able to canvass these ballots. And so finally, on Friday, we finally had our hearing. However, about 4 days before the hearing, Mr. Glickman left the case. And Charlene Tarver, once again, was acting pro se, representing herself. She did some response paperwork that we argued was unresponsive to our memorandum of law that was clearly saying that the board has to count these ballots and we have to move forward with this election. But Judge Neary was very clear that he wanted to give Ms. Tarver her day in court. In fact, we made a motion at the beginning of the court to dismiss the petition outright. We didn't feel there was any chance of her presenting a case based on the witnesses that she wanted to give, based on her response paperwork, that would overturn the election. And but Mr. Neary, Judge Neary, wanted. He was very clear he wanted to give her a chance to present her case. He felt that, in his words, that everybody in this courtroom gets a chance to be heard, and he wanted to spend the day do that. And we did. It was a 7-hour hearing on the 14th. It was a very frustrating hearing because Ms. Tarver has not practiced law in quite some time, I think, and I'm trying to be as generous as possible. The court case, in the words of Riley Kirk for Syracuse.com, was a mess. And I'm not going to go too much into that because, I shared that article the other day, and Riley did a really good job of reporting what happened in that courtroom. But it became very clear as the day wore on that Ms. Tarver was fishing to try to prove fraud in the case without actual proof of fraud, and wanted to have the judge basically ignore the law and not count the 14 ballots that are in our possession. Now, I need to be very clear. We don't know whether these ballots are going to overturn this election because we haven't opened them yet. But since they were procured by agents of the Bullock campaign, it's presumed that they know these people and that they were probably voting for Miss Bullock. That being said, on Friday, at the end of the day, the judge waited a half hour, went back to his chambers, wrote a decision, and came back and ordered the petition dismissed, said there was no fraud presented in the case, and had us move forward with counting. So we are because this happened late in the day on Friday, we couldn't go back that day and do it. So Commissioner Ryan is scheduled on a family vacation for Monday to be out, which is allowed. We aren't supposed to be doing this in August. And I have no problem with that. I want to be very clear that I'm just putting the facts out there. It's August 14th. We should be getting our vacations in. August is the time we take time off before Labor Day, before the big election. So, that's part of our frustration with this case that has gone on and on. It has prevented us to start from designing a ballot and getting prepared for the general election. That being said, on Tuesday at 9 a.m., we are finally going to canvass the 14 cures that are before us and then count them. And then on Wednesday at 10 a.m., we will proceed to a hand count. The race is, no matter how these 14 cures go, the race is within 20 votes, most likely from the winner to the second place, and thus by law we have to do a hand count. So we're going to do that on Wednesday, and presumably Wednesday afternoon we will certify this race and finally be done with the 2024 or 2026. Hasn't gone on that long. 2026 June primary, and then move on to the general election. So that's what happened on Friday. It's kind of one of the reasons I've been a little absent is dealing with that. The other reason I've been a little absent is the veto non-veto resolution for term limits that has taken over the airwaves in Syracuse. I've never really been a part of something like this before in terms of public scrutiny of this issue. I released a statement about a week ago or so. I initiated a lawsuit. I believe it was August 5th. I initiated a lawsuit to sue my counterpart, Kevin Ryan, because I felt he, without reason, has been blocking this term limit resolution that was delivered to us by the Onondaga County legislative clerk, that was signed into law by Ryan McMahon. His claim is, well, he meant to veto it, so it's not really law, and that a veto was done later that day. And, I've been very clear about all of this. I think the county Democrat legislature has been very clear that, and we actually have two separate positions, although we have the same lawyer now, with Steve Williams, representing us of Smith-Sovic. But in this lawsuit, my position was, I don't care about the veto, non-veto. It was delivered to me by the county legislative clerk. It needs to go on the ballot. We don't have a role in saying it doesn't. And Mr. Ryan believes we do, and so far has blocked it from going on the ballot because the deadline for that was August 3rd. Even though the transmission happened on July 17th, I felt like it was too early to go to court back then based on what our research was with my attorney about when the proper time to file a suit was. It's within 72 hours of that August 3rd deadline, which we did. Now, the county exec has retained counsel. The county ledge has retained counsel. Neither one has so far officially entered this court case. I expect all parties to. I've said that all along. That's nothing new. I'm not breaking any news here. I expect all parties to enter this lawsuit. Hopefully, we will have some kind of resolution on this. I want this on the ballot this year. And it's very clear. Now, I'm not going to negotiate through the airwaves. I just want to be clear with the viewers, what few I have, where I'm at on this. I want this on the ballot this year. I want the 12-year term limit on the ballot. I feel there's no legal way to block this. That being said, I recognize the timelines on all of this, but there is a democracy question here about whether one commissioner can decide to block a resolution. And this is virgin snow. We don't know. I don't know where this is going to end up. And I don't know if the timing is going to end up. But I just know that I'm going to fight like hell to try to make it that way, because I believe that's the way the law reads. However, if a judge says it's different, we'll see. Judge Lamondola has the case. We were originally going to go to hearing on Tuesday. That's been pushed as parties are negotiating the schedule along with other things. And we're waiting to see whether the county ledge and the county executive are going to join the fray. So that's the two court cases I've been dealing with. I'm going to try to get back to regularly scheduled commissioner in the cards each week. Next week I'll be talking on, and I'm going to try to do it on Sundays, because I think Sundays is better for me. I get very tired after a work day. Why? I don't know. But I get very tired after a normal work day nowadays. So I think Sundays is probably going to be better. I'm going to go back to Sunday commissioner in the car sometime in the afternoon or early evening. And, but next week we'll be talking about judicial conventions, because, we will have the listing of the judicial conventions throughout, Onondaga County and the 6 counties that make up the 5th judicial. And I'll talk about that next week. Join me next week on Sunday for Commissioner in the Car. Bye-bye.